My name is Wesley Shackleford. I'm a Deputy Director and Special Counsel at the new Texas Indigent Defense Commission. And briefly, I wanted to tell you about one of the other things we work on besides indigent defense, and that is through a legislative initiative. We provide fiscal support to our 4 public law schools in Texas that have law schools for the operation of innocence projects. And those include the Texas Center for Actual Innocence here at the University of Texas, the Texas Innocence Network at the University of Houston, and I think Cassandra Chu is going to be here today. In fact, there she is in the auditorium. We also have the Innocence Project of Texas, based at Texas Tech University, and it's represented by its director, Jeff Blackburn, who we'll be hearing from later today. And the 4th school is the Texas Southern University's Thurgood Marshall School of Law, and I'm here to introduce its director, Anthony Haughton. Professor Haughton is the Associate Director of the school's Earl Carl Institute Center for Criminal Justice. He's been a licensed attorney since 1989, and he's currently in charge of the Thurgood Marshall School of Law's Innocence Project, where he runs the Innocence Project Clinic, as well as teaching the Innocence Project class. He was formerly the trial chief of the Public Defender Service of Washington, D.C., and has dedicated his career to assisting persons accused of crimes in both trial and the appellate level. And with that, I'd like to welcome Professor Haughton.
It's my pleasure to introduce the 2 next speakers, Dr. Tony Fabella and also Senator Rodney Ellis. Dr. Fabelo is currently in charge of designing, developing, and implementing a research agenda for the Justice Center. From 1984 to 2003, he was with the Texas Criminal Justice Policy Council, where he was appointed by Governor Ann Richards. In 1991, he was elected to run a division over there, and he has served under 5 governors, including our 2 most recent governors. In his different capacities in Texas, he has assisted every single legislature that we've had since 1985. He has helped develop a reinvestment initiative, which was adopted by the Texas legislature in 2007. The U.S. Attorney General appointed him to the Office of Justice Programs Science Advisory Panel in 2010. Dr. Fabelo received his BA in Political Science from Loyola University, and then received his MA and PhDs from the University of Texas. He is now currently based in Austin, and we're going to introduce him to come up to the stand in just a moment. I want to give an introduction of Senator Rodney Ellis right before that. Senator Rodney Ellis, as many of you know, was elected to the Texas Senate in 1990, and since then he has earned praise in various areas, but none less so than the criminal justice area. And during his tenure, he's become nationally renowned as a leader on Texas criminal justice reform. He has helped in the passage, was instrumental in the passage of the Texas Fair Defense Act that we are here celebrating its 10th anniversary today. The Fair Defense Act dramatically and forever changed the face of Texas justice by focusing on and tackling 4 critical issues. Firstly, the timely appointment of counsel. Second, the methods by which counsel were appointed. Third, the processes by which counties reported on their provision of indigent criminal services. And finally, the setting, for the first time, of minimum standards for appointed counsel. The Texas Fair Defense Act was also responsible for the creation of the task force that is now renamed as the Texas Indigent Defense Commission. In 2009, Senator Ellis was instrumental in passing the Timothy Cole Advisory Panel and getting that set up. And that panel itself is named after Timothy Cole, who was a young man that was innocently, wrongfully convicted of a very horrific crime. Unfortunately, before his innocence could be proven before the courts, he died in prison. And the panel was named after him, and the panel looks at all of the different reasons from the DNA case perspective as to why innocent persons get convicted, wrongfully convicted. In 2011, Senator Ellis was able to pass a number of other top priority criminal justice reform bills, including one that looks at the biggest cause of wrongful convictions, and that is eyewitness misidentification. And now we have in place a law that is requiring every single Texas law enforcement agency to look at and then enact best practices for their eyewitness identification procedures. Another reform that he passed in 2011 was to ensure that where DNA exists in cases and where it can help prove the innocence of somebody, that it will and actually can be tested. Before his election to the Texas Senate, Senator Ellis served 3 terms as a member of the Houston City Council and was the chief of staff to the late U.S. Congressman Mickey Leland. He has a bachelor's degree from Texas Southern, a master's degree from the Lyndon B. Johnson School of Public Affairs. He received his law degree from the University of Texas School of Law, and he's also studied at Xavier and the London School of Economics. Rodney Ellis is married to Alicia Green Ellis and has 4 children. It's my pleasure to welcome Dr. Fabelo to the stand and to introduce both of these men.
I decided, a couple of people already told me this morning, I said, well, you're going to do the same old stuff that you always do, right? Recycle your last presentation to the commission. That's not good. That doesn't increase your confidence as you're walking in through the door. But so I'm like, maybe I'm going to do a slightly different thing because we're going to do a little bit of the bureaucraties where we're going to talk. I try to frame for you the progress that we have made with the impact of the Fair Defense Act, because it's good to have that perspective. And then the last part, kind of framing the whole conversation for the day. What are the challenges that we are expecting for the next 10 years? But I told Jim, I said, I want to look at the roots of this stuff, because in these bureaucraties, we sometimes forget, why do we even have a right to counsel? And I took advantage of one of my kids that is in the film industry to help me put some little film together that I think will bring it home. So if you can do that, Terry, we'll do that first, and then we take it from there. Let's see if this works. Should work.
What does this letter say?
I thought Your Majesty just read.
I asked you to tell me what this letter says, my Lord Hertford.
The letter accuses Queen Catherine of dissolute living before she was married to Your Majesty.
I charge you to investigate the matter thoroughly. Do not desist until you reach the bottom of the pot.
My lady, you are confined to your apartments, with only Lady Rochford to attend you, for as long as it please the King.
Did you know Catherine Howard at Lambeth when she was 14 or 15 years old?
Yes, sir.
Did you have carnal knowledge of her?
We played some games.
I thought you were not altogether honest with me, Mr. Derham. I wanted to show you what we do to people who are dishonest, who don't tell the truth.
I'll tell you the truth.
You're doing this! I've already told you everything I know!
His hands, my love. His hands.
What are you going to do to me? No! 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 No!
This is His Majesty's letter. In it, he offers you mercy, despite the grievous offences you have committed against him. If you will only openly confess your faults. There. Do you see? Who is he?
Your groom, Thomas Culpepper.
That any pleasure that wicked bitch got from her wantonness will be nothing, nothing! In comparison to the pain she's gonna feel at the hand of my torturers!
Going back to the roots, if you look at the Declaration of Independence and you pass the first preamble, we're all created equal and all that, and you get to the grievances that they listed, was the deep consciousness of these people at the time that the king will use the judicial process to basically screw with you and do stuff with you by controlling the judges and so forth. So the founding fathers kind of knew that. They put that in our Bill of Rights in 1791. And 5 of the amendments related to controlling judicial power, related to the boundary between the state and the individual. And that's the roots of this sin, is the ability to protect the individuals against abuses by the state and the use of the state of the basically judicial power to do that. So we had the right to counsel that eventually was passed to the state, to the Gideon decision, as you know, where the court said that for indigent defendants, we need to provide counsel. And this is the quote from the Gideon decision. And one thing that struck me when I was looking at the history of this sin, going back to Henry VIII, actually I went back to the Magna Carta. That was the first time that they tried to set the boundary between the power of the king and so forth. And that's a fascinating story because King John turned around after signing the Magna Carta and killed all his barons and say, screw that, I'm moving on as a king, and it took a long time to get here. But one thing that struck me was that, in fact, during colonial times, Norman, you might know more since you have a deep sense of history, you have to hire a prosecutor. There was not a formal apparatus of the state. So you have to go and hire a prosecutor that will file the charges. It's later that we put together this gigantic apparatus, and it's truly gigantic today, where the state can use their immense power from Homeland Security, DPS, police, all the way to prosecutorial power to come to the individual and say you have done something wrong. And the only protection that individual has against this power of the state, or one of the protections, is the right to counsel, and this is why it's significant. So between Gideon and 2001, where we created the Texas Fair Defense Act, Rodney Ellis sponsored this, we really were struggling to how to translate this into an effective program to deal with indigent defense. And we're looking now at the last 10 years of implementation. So getting back to the Jeff Blackburn point about cave dwellings, really, when you think about it, it took 560 years from the Magna Carta to the Declaration of Independence, 16 years to the Bill of Rights, 172 years from the Bill of Rights to Gideon, okay? 38 years from Gideon to the Fair Defense Act. And if you look at the whole thing from the adoption of the Sixth Amendment to today, the Symposium, 220 years. And if you look at it, almost 800 years since the Magna Carta. So, Jeff, you are totally right. We're going to look pretty good when you put it against this timeline. But in doing this, it was really, really telling how long it takes, how long is the path of history in terms of this continual evolution between, the state and people that control the state and the right of counsel. You think it's working? So what happened, as you know, before the Texas Fair Defense Act, there were a bunch of grievances against the system of indigent defense in Texas. You can read them there, but basically there were no consistent standards. There were issues about perceptions of cronyism with the judges appointing lawyers. There was no transparency. There was no information to really know how much money was being spent in the state. There were issues about the qualification of counsel and so forth. Very, very real grievances that came to a head in 2001 with the Fair Defense Act. And what the Fair Defense Act did, it put the infrastructure that was critical to start improving the indigent defense system. And this is the key, and this is the value of what Rodney Ellis and the people that sponsored this put in place. And this is the value of what the Commission have done for the last 10 years. So you have the process standards where all these components are now in place that were not there before. We have standards now about the timing of appointment, the method of appointment, compensations and qualifications, state funding for the first time. Funding subsidies were set up and grants for improvement. And then we have the oversight, of course, which provided for the transparencies, the plans, data, and audits. And all this is to lead to the improvement of the quality of representation, which at the most basic level is to meet constitutional standards. At the second level is to have some prima facie legitimacy that these standards are in place. More important and more tricky, and I'm going to talk about that in the third part, is how do we improve outcomes and how do you even know that we're doing that. The CREEC process standards that were implemented, I just list them and you can read them there. But basically we have a system now that provides for all the elements there. There was a very predetermined policy to use some of the funding to start implementing what we call standard-based programs like Public Defender's Office to help with the Innocent Project. And then, of course, the compliance aspect of this and the oversight that have been put in place. And most recently, to my surprise and to the great credit of Senator Ellis, we were in a, where were we? In Pecos County in a strategic planning session, and I threw on the table and said, you know, the task force is not good, it's not independent enough. Carl Reynolds is there, and I'm saying they need to take it out from Carl Reynolds because he should not be controlling the budget of this. And to my surprise, I thought I would be booted out of the room, and to my surprise, that led to a pretty good discussion that led to the framework that we have now for the Indigent Defense Commission. And Carl, I honestly commend you for that, but because your typical bureaucrat will be fighting to keep the Senate in and keep the resources, and Carl did not do that and actually promoted the idea because he thought it was the right thing to do to improve the next step. We have other standards in the law and some of the expansion of the Federal Defense Act you can see there. So I think even by not the cave dwelling standards that Jeff said that I was using, but just by the standards of the last 10 years, we have made a lot of progress in Texas in this area. And one big one that we're about to set up is the Harris County Public Defender Office. As you know, Harris County has more people than 27 states or something like that. And so it's like a state of its own. And for a long time, they have never had a public defender office. And that is being set up. Alex Bunning is here. He's going to speak in a little bit about what they're trying to do. But it's going to be a major operation relative to what we have done here in Texas. And we're going to try to work with Alex and his people to learn about how to put this stuff together. More important, how to even evaluate it to provide information along the levels of cost effectiveness, more important outcomes, and one of the sessions coming up will discuss that. So really, by those standards, we have done very well. It took a long time to get here, but once we got going in 2001, we have made a lot of progress thanks to all this. So let me look at the next 10 years, because like Carl said, it's going to be very, very challenging for a bunch of reasons, as you know. I think, we think, I guess, because we have reviewed this with Jim and George Keller and so forth, that the next set of challenges is to develop caseload standards and develop the managed assigned counsel system standards. There are going to be conversations following this presentation about the challenges of that. In terms of funding, and this is going to be a big one, increase the state subsidies to counties and then increase the funding for so-called standard-driven programs. And those are like public defender office and the assigned counsel, managed counsel system. And then accountability. We need better accountability with better tracking of information as to potential caseload sites for assigned counsel. We have an idea on that. We don't think it's that hard to do. And then a formula that encourages the successful continuation of the programs that we have. And one of the most critical challenges in the next 10 years is, what do we get for additional funding? How can we show that we have improved the quality of indigent defense, and what is it that that means in terms of this building? Because the way this building works, increasingly so, is that you need to show a so-called return on your investment. If you go here to any of the committees and say, I want money for this, they're going to say, well, what do we get out of that? And this is an important conversation. Let me give you a sense of those numbers now. It costs the local people $167 million to pay for indigent defense services. The state provides $28 million, which is 14% of the funding. And as you can see there, the funding has increased because the population has increased in this state, because the number of cases have increased in this state, and because the standards have been imposed, and that affects some of the costs. At the end of the day, when you do it on a per case basis, you have in 2010 about $342 is the payment per case for indigent defense. So if you look at the state of Texas, the population is about to increase. Not about to increase, it has been increasing for the last 10 years. These are the official projections from our data center. And there are different lines depending on different assumptions about migration and so forth. But any of those lines mean that the population, no matter what, will continue to increase. And more importantly, we have a large portion of our population that is poor, under poverty. We have the nine highest percentage of people under poverty in the country. So if you relate poverty to the need for indigent defense, then that gives you the full picture of what's coming up. So here are historically the number of cases going up 30% to 2010, and projected, just based on a line projection, making some basic assumptions, that 10 years from now, we may have to pay for 640,000 indigent defense cases. And that assumes that they will continue to increase and so forth. So here is the question: to maintain the present level of funding, to maintain the present $300 and some per capita, and the same distribution of funding with the counties, it will take an additional $68 million by 2020 or 2021 of state funding. That's just to maintain what they will call around here current level of services. If you go into an aggressive mode, you say that, and actually the percent local will decrease if we can do that. If you want to increase it by $50 per case of reimbursement, from 360 or 45 to almost 400, you will need $110 million in additional money in the next 10 years. And I don't have to tell you about the situation with the state and so forth. If you do that, the percent local will decline, assuming that the locals don't continue to input more money into the system. So here is the future political challenge, and something that we need to discuss during the day. So what do you use the increased subsidy for, or funding for? Do you use it for just increasing the formula subsidy to the counties, or do you target these funds to very specific initiatives like services for juvenile mentally ill offenders that, like the Commission has been doing now for a while, local standard-driven programs like Public Defender Office? And more importantly, when you are around here and somebody asks you, if I give you $15 million more, putting aside the politics of the counties and the counties going there and say, we need money, that alone can be a rationale. But if we give you $50 million more, what do I get in return? Is justice better? And how can you say it is? And it's a very, very tough question, and something that Amy back, where's Amy? Amy, yeah, back out there? Amy is going to talk about it after Senator Ellis' presentation. But if you read her book, it shows you what she calls ordinary justice, where the system is a large processing machinery, and she's arguing that people, even within the system, cannot recognize what will be the true justice outcome. And then towards the end of the book, she's raising the challenge, which is the same one I'm raising here for Texas. How do you determine what qualifies as a good outcome, and how you can do this? And this is the demand for teachers, this is the demand for every state agency, and so forth. So this is coming, and I think it's very challenging. But to conclude, basically, congratulations to Rodney Ellis, Senator Ellis, and Judge Keller, Jim, and everybody that has participated in the last 10 years to set the infrastructure that we can truly say that at face value, when you look at the Texas system today versus 20 years ago, 15 years ago, at face value, we are doing a hell of a lot better. And then the challenge for the next 10 years is how to build on that infrastructure by looking at the funding picture, by looking at minimum standards, by documenting and start thinking better what is it that we get in terms of justice out of additional funding, so we can make that case in this building, because this building is increasingly tougher to work with around here. And that's just the reality. That is what it is. So anyway, thank you again, and I'll pass the torch to Senator Ellis.